The Labour Standards Act affects just about everyone who lives and works in Saskatchewan. Administered by the Department of Labour and its offices across the province, the Labour Standards Act applies to most employees and employers in Saskatchewan. But there are some occupations not covered by it. Farm labourers, for example, are not covered by Saskatchewan labour standards, nor are people who work in industries under federal jurisdiction, such as banks and grain handlers. Other employees are exempt from parts of the Act. For example, doctors, teachers, and lawyers are exempt from the hours of work and overtime provisions. Give us a few minutes and we will tell you more. We will examine the law under 3 categories: time, money, and job loss.
Let's start with time, which there never really seems to be enough of. This includes overtime, public holidays, maternity, adoption, and parental leave. For most people, overtime begins after they've worked 8 hours in a day or 40 hours in a week. The overtime rate is 1.5 times the employee's hourly rate. There are some exceptions to this overtime rule, such as professionals and managers. If the employer and a majority of employees agree, a special permit to allow flexible hours may be obtained from the Director of Labour Standards. Daily hours of work may then be changed to allow hours other than the typical 8 hours a day. Flexible hours of work, such as 10 or 12-hour shifts, may also be negotiated with the employees' union. Finally, except in emergency circumstances, employees may refuse extra work once they have worked 44 hours in a week.
The 10 public holidays in Saskatchewan are New Year's Day, Family Day, Good Friday, Victoria Day, Canada Day, Saskatchewan Day, Labor Day, Thanksgiving, Remembrance Day, and Christmas Day. Most employees employed at the time of the holiday get public holiday pay no matter what their days of work. Public holiday pay for that day is defined as 5% or 1/20th of the employee's regular wages earned in the 4 weeks before the holiday. There are some exceptions to this rule. Employees who work on a public holiday must be paid at least time and a half their regular wages in addition to their regular day's pay.
Birth mothers and the primary caregiver of adopted children are entitled to take 18 weeks of maternity or adoption leave and an additional 34 weeks of parental leave for a total of 52 weeks to care for newborn or newly adopted children. If parental leave is taken with maternity or adoption leave, both leaves must be taken consecutively. The other parent can take up to 37 weeks away of job-protected leave. Parental leaves must end no later than 52 weeks after a child's birth or adoption. For these leaves, employees may qualify for federal employment insurance benefit payments. Questions about these benefits should be directed to the nearest Service Canada office. Employees cannot be laid off, terminated, disciplined, or suspended because they apply for or take such leave. Following this leave, an employee must get his or her old job back or a comparable one. In most cases, an employer must be notified at least 4 weeks before leave begins and 4 weeks before an employee intends to return to work.
The Labour Standards Act includes provisions for the posting of schedules, prorated benefits, and meal breaks. In most circumstances where benefits are provided to full-time employees, proportionate benefits must be offered to part-time employees who work more than 15 hours a week. Work schedules are to be posted in at least 1-week periods and must identify both the hours of work and times for meal breaks. Most people are entitled to a 30-minute unpaid meal break if their shift lasts 6 hours, except where emergencies or unforeseen circumstances may make that unreasonable.
Now, let's talk about money, one of the great incentives to work anywhere. The Labour Standards Act has legal requirements regarding minimum wage, annual holiday pay, benefits, and equal pay. The minimum wage is an hourly rate. If an employee reports to work as required, but there is no work, then he or she is paid a minimum amount called minimum call-out pay, or their hourly wage for the time at work, whichever is the greater amount. Exemptions to the minimum call-out rule include students attending school, janitors, and building cleaners.
All employees, including students, are entitled to annual holiday. After 1 year of work, an employee is entitled to 3 weeks annual holidays with pay. After 10 years, 4 paid weeks. The employer may decide when annual holidays are taken. If annual holidays are scheduled and agreed to by the employer, and the holiday is canceled by the employer must pay all verifiable, unrefundable losses resulting from the cancellation. If an employee leaves before working a full year, their holiday pay is 3/52 of total wages earned at that job.
Some benefit plans are offered to employees as a wage package. These plans might provide coverage for death, disability, prescription drugs, and dental expenses. It's important to know that if an employer with the equivalent of 10 full-time employees provides a benefit to staff who work more than 30 hours a week, then the benefit must also be provided to employees who work at least 15 hours a week. There are some exceptions to this requirement.
The Labor Standards Act also says male and female employees are entitled to equal pay for work performed in the same workplace under similar working conditions, requiring similar skill, effort, and responsibility. For instance, suppose a man and a woman work in an office supply store. The woman packs shelf items into small boxes for shipping, and the man then packs those boxes onto a pushcart and then onto a truck. Their jobs are substantially the same. Both must be paid the same wage since both require the same skill, effort, and responsibility. That's equal pay. A woman cannot be paid less for doing substantially the same kind of work a man is doing in the same establishment. Nor can a man be paid less under the same circumstances. Differences in pay must relate to merit, seniority, production system, or some other non-sex related criteria.
Unfortunately, there may come a time when a worker no longer gets paid. The business could fold or the employee might be let go. In the event of job loss or layoff, you should know about notice and pay in lieu of notice. To qualify for notice, an employee must have worked for the same employer for at least 13 consecutive weeks. Then, should the employee be terminated for lack of work, the employer is required to give written notice to a maximum of 8 weeks based on an employee's length of service. Once notice has been given, an employer must pay regular wages and benefits until the notice period ends, even if there's no work during the notice period. If a person decides not to work for the notice period, an employer only has to pay your wages to the last day of work. Notice provisions do not apply if someone is fired for just cause, or if they're laid off for less than 6 days. Just cause is not defined in the Labor Standards Act, but the courts have ruled just cause may exist if you're guilty of serious misconduct, such as stealing. Where no notice of termination is given and just cause does not exist, the employer must pay the worker the normal amount that they would have earned during the notice period. This is called pay in lieu of notice. If the employer is given notice and has paid regular wages during this notice period, workers are not entitled to pay in lieu of notice.
Special provisions in the Labor Standards Act provide protection for those who report illegal activity and for employees who become ill, injured, or disabled or are absent from work due to injury or illness of an immediate family member. This includes employees who are temporarily away from work to care for a family member who is gravely ill and are receiving or in the waiting period to receive compassionate care benefits. For more information on these benefits, contact your nearest Service Canada office.
Violations of labor standards can lead to fines of $2,000 for the first offense, $5,000 for the second offense, and up to $10,000 for the third and subsequent offenses. Claims for unpaid wages must be registered within 1 year of the day on which the wages being claimed were due. These penalties show how seriously we take the business of maintaining fair labor standards for people in Saskatchewan. Employers and employees alike have rights and responsibilities in the workplace. Everyone, employers and employees, expect fair and equitable treatment in the workplace. The Labor Standards Act sets the ground rules for that. It's a good deal for everyone in Saskatchewan.
We've produced this video to familiarize Saskatchewan employees and workers with the Labor Standards Act. Since many details could not be included, You should consult the Act itself on matters such as money, time, and job loss, or contact the nearest Labor Standards branch office.